Hello students, welcome to KANISHKA IAS. As all of you know, we have started a series of videos regarding the polity and governance where we are trying to identify certain repeated themes in the examination. So as a part of our series of videos, we are today going to discuss about the Constitution Amendment. Why? Because UPSC started asking about articles, clauses and subclauses, even the Supreme Court judgments as statements. They may not mention the Supreme Court judgment as it is, but they mention the Supreme Court judgment in this form of a statement. So that's why we need to understand every dimension of such kind of information. So before we attempt to discuss that particular topic, let us take some sample question which was asked in the UPSC prelims. Coming to the question, consider the following statements. Okay, there are three statements given. One is regarding whether the prior recommendation of the President of India is required for the bill or not. Number two is regarding when it is presented to the President, is it compulsory for the President to give assent or not? And number three, whether the bill requires a joint session or joint sitting. And moreover, the statement is also related to the nature of or type of majority required for the passage of the bill. So here the options are given. So before we attempt this particular question, let us get into the topic. In fact, the Constitution Amendment is provided under Article 368 of the Constitution. Article 368 provides both power to amend the Constitution as well as procedure to amend the Constitution. Article 368 contains 5 clauses. Okay, so textually there are 5 clauses, but clause 4 and clause 5 have been nullified by the Supreme Court in Minerva Mills versus Union of India, 1980. So in this particular judgment, the 4th and 5th clause of the Article 368 have been invalidated, right? So before we understand Article 368, let us understand the purpose behind Article 368. Because the constitution makers in the Constituent Assembly itself, they have debated about the importance of the Constitution Amendment, right? For example, if you try to look at two important personalities like Dr. B.R. Ambedkar as well as Jawaharlal Nehru, both have presented their views. Especially Dr. B.R. Ambedkar said, Constitution is nothing but living document. Constitution cannot be remain to be a dead wood. Constitution must be able to embrace the changes that are happening in the society when the time changes. So moreover, even Jawaharlal Nehru also has given his opinions stating that Constitution shall be permanent. Okay, you can't abolish the Constitution. But what Jawaharlal Nehru also said, the Constitution must ensure changes. So I think you are able to understand the difference. Constitution shall be permanent. So it means there is no other thought whether the Constitution is required or not. But when it comes to the changes in the Constitution, the changes must be adaptable. And moreover, in the Constituent Assembly, there were two models have been considered. One is the model of UK and the model of USA. As you know very well, UK model does not provide any rigidity for the Constitution. Why rigidity is not there? Because there is instead of constitutional supremacy, there is parliamentary supremacy. So in the parliamentary supremacy, you are able to see two things. Number one, Parliament has ultimate power to make any changes to the Constitution. In fact, in UK, there is no specific document called as Constitution. But every ordinary legislation can be considered to be part of the Constitution. Hence, UK's Parliament has unlimited power to change the Constitution. And number two, there is no concept of judicial review in UK. So no judicial review. It means judiciary, by means of its power called as judicial review, cannot nullify the Constitution Amendment. Whatever the Constitution Amendment is there, that cannot be invalidated by the judiciary. So that's why in UK we can say there is parliamentary supremacy. Coming to the United States of America, where you are able to see two types of features. Number one, federalism. Number 2, supremacy of the constitution. Okay, because of this reason, in UK or in USA, you are able to see rigidity of the constitution. Rigidity of the constitution. Why rigidity? Why? Because in the constitution amendment process, the role of the states is very, very maximum. So in other words, for example, if American Congress initiate the constitution amendment by 2/3 majority in both houses, subsequently every such amendment must be ratified by at least 3/4 of the states that are there in America. Out of 50 states, 3/4 states must be ratifying such amendment with 2/3 majority, right? So it means every amendment must be able to be ratified by the states, okay? But in the case of UK, there is no such involvement given to the states, because in UK there is only unitary government. There is no federal government, okay? So that's why in UK you are able to see flexibility given to the constitution. In USA you are able to see rigidity given to the constitution. So in the Constituent Assembly there was a debate. So what kind of constitution we need to ensure? So Jawaharlal Nehru ensured we need to provide not just rigidity but also flexibility, because we can't make constitution amendment so much complex nor so much easy, so that we are able to ensure two things. What is that? Permanence of the constitution, but not permanence to the constitution provisions. This is how this particular system has been adapted. This has to be called as semi-rigid constitution. Okay, this feature is nothing but semi-rigidity, right? That's the reason why the constitution amendment process has been made to be more a kind of procedural aspect in the original constitution. That's why in the original constitution, the constitution amendment became very much a process of procedure. In other words, Article 368 of the constitution did not originally provide the term power, rather it provided only procedure. But later what happened? This particular aspect of the constitution came under the controversy, especially related to right to property. We will be discussing this topic in a separate video, right? So as far as this right to property is concerned, there was a fundamental conflict between Article 31 of the Constitution, Article 31 Class B and Class C. So Class B and Class C is about distributive justice, and 31 was right to property, and Article 19 Class 1 subclass F as well as Article 14. So in order to provide the conciliation between Article 31, 19 Class 1 subclass F, Article 14 on one side, 31 Class B and Class C on the other side. So these are nothing but fundamental rights. These are nothing but directive principles of state policy. In order to provide the conciliation, what was attempted? The constitution amendment was attempted. Constitution amendment. Okay, and this constitution amendment was made to Article 31 by including Article 31A and 31B by both the first Constitution Amendment Act, and 31B was also supplemented by 9th schedule. So in other words, if any act is made and included into the 9th schedule of the Constitution, such law cannot be questioned in the name of judicial review. So judicial review will not be possible. So in other words, the right to property was diluted by means of the amendments. Later, this particular dilution or this particular amendment was questioned in Shankari Prasad case, where Supreme Court said the amendment to Article 31 is not unconstitutional. Why? Because Article 13 of the Constitution, especially under Article 13 Clause 3, there is no provision for constitutional amendment, because 13 Clause 3 describes what is law. In the description, constitutional amendment was not provided. In other words, Article 13 Clause 2 will be applicable only when the constitutional amendment is provided under Article 13 Clause 3. Article 13 Clause 2 about invalidation of the post-constitutional laws. If it is to be applicable, the constitutional amendment must be considered to be law. But what Supreme Court said, constitutional amendment is not law under the definition of Article 13 Clause 3. Hence, Supreme Court in Shankari Prasad has explained this particular issue and said that constitutional amendment is valid. The first Constitutional Amendment Act is valid. Similarly, Supreme Court has reiterated the same opinion in Sajjan Singh versus State of Rajasthan. Okay. In this also Supreme Court said the constitutional amendment is valid. Why? Because same Article 13 Clause 3 does not provide constitutional amendment. So hence Constitutional Amendment Act is nothing but it is not law. It is not law. So when it is not law, judicial review is not applicable. Why judicial review is not applicable? Why? Because judicial review is applicable only on law. So since Constitutional Amendment Act is not law, hence judicial review is not applicable. So this was the opinion given by Sajjan Singh's case. Okay. Then later, Supreme Court in Golaknath versus State of Punjab held its opinion that in fact constitutional amendment, okay, it is not the power of the parliament. Okay. Why? Because Article 368 mentions only about procedure but not power. Not only that, if any amendment takes place with respect to the constitution, any other part can be amended except fundamental rights. But you understand, if the fundamental rights are not implemented or fundamental rights are not amended, what will happen? The property cannot be distributed. Why? Because the DPSP such as Article 31, Class B and Class C faces the hurdle of right to property. So we need to dilute the right to property in order to implement the Article 39, Class B and Class C. Okay. So this became a hurdle for the implementation of the distributive justice in the country. Not only that, in order to amend the constitution, the Supreme Court also said there is a requirement of a constitution convention. Okay. So this made the constitution to be extremely rigid. You understand? I have discussed with you, according to Jawaharlal Nehru, the constitution amendment process in India is not molded specifically on the lines of the USA nor on the lines of the UK's procedure. But in India, we taken the mix of both rigidity and flexibility. Because of the Supreme Court's verdict in this particular case, the constitution became extremely rigid, which is completely against the very intent of the constitution framers. Hence, this particular situation was to be addressed by another constitutional amendment, that is 24th Constitutional Amendment Act. We are not discussing about 25th Constitutional Amendment Act. Okay. Actually, this 25th Constitutional Amendment Act has provided the supremacy to 39 Class B and Class C over Article 19 Class 1 Subclass F, Article 14 and Article 31. So this is a separate discussion. So let us focus upon 24th Constitutional Amendment Act. This 24th Constitutional Amendment Act has provided amendments to two particular articles, Article 13 and Article 368. Okay. So what Supreme Court said in the Golaknath case, Parliament has no power to amend the constitution, and in order to provide the amendment process, you need to constitute the special constitution convention, which is extremely rigid. So there was an effort to restore the powers of the Parliament by means of the 24th Constitution Amendment Act. So for this reason, two important changes have been made with respect to Article 13 and Article 368 of the Constitution. What are such changes? These changes include, first one, 13 Clause 4 was added. 13 Clause 4 says the Constitution Amendment Act is not law. Okay, what is implicitly provided under Article 13 Clause 3 has been explicitly, that is openly provided in the form of 13 Clause 4. And moreover, to the Article 368, certain changes were introduced. One is the marginal note. Every article will be having the marginal note in the original constitution. So this is, suppose this is an article, okay, here you can see the marginal note. So in the marginal note, the change was brought. What is the change? The term power has been added to the marginal note. And not only that, to the Article 368 Clause 1 itself, the term power has been added. So it has been mentioned, the constant power, the constant power of the Parliament. This constant power of the Parliament will enable the Parliament to make three important things. One is addition, that is adding any new provision to the Constitution, repealing any provision to from the Constitution, and also making the variation. So these three terms have been added to Article 368 Clause 1. And apart from that, even the term constant power has also been added. So this is how Parliament tried to restore its power, which has been nullified by the Supreme Court in the Golaknath case, right? So now the Parliament can do anything. Not only that, even under Article 368 Clause 3, under Article 368 Clause 3, it also mentioned Parliament has unlimited power. Okay, in other words, it was clearly mentioned that the Constitution Amendment is not law under Article 13 Clause 3 of the Constitution. Okay, so Constitution Amendment does not fall under the meaning of Article 13 of the Constitution. So that was reiterated under Article 368 Clause 3 of the Constitution. Of course, this unlimited power is not added explicitly, but the very meaning of Article 368 gives an impression that Parliament has unlimited power to amend the Constitution, right? And moreover, the Supreme Court in Golaknath case held that, Constitution Amendment is nothing but law. So this was reversed by 24th Constitution Amendment Act, stating that Constitution Amendment is not law. So this is what the essence of 24th Constitution Amendment Act, right? So then what happened then? Then the consequence was challenging this 24th and 25th Constitution Amendment Acts in the K7 and the Bharti case versus State of Kerala, 1973. In this particular case, these 24th and 25th Constitution Amendment Acts have been challenged. Then what happened? The question was whether Parliament has limited or unlimited power to amend the Constitution. This particular question was examined by the Supreme Court in the detailed manner. So there was 13-judge bench which has examined this particular, the validity of the 24th and 25th Amendment Act. Why? Because Supreme Court previously held that Parliament has only limited power to amend the Constitution. That was reversed by 24th Constitution Amendment Act. Then what Supreme Court said? The Supreme Court said specifically that the Parliament has unlimited power to amend the Constitution. Okay. So there is no restriction upon the power of the parliament to amend, but subject to basic structure doctrine. So basic structure means certain fundamental elements of the constitution cannot be subjected to any manipulation or any violation. For example, Supreme Court did not codify what exactly the basic structure, but it has given some outlines in the form of like democracy, secularism, republican feature of the constitution, rule of law, separation of powers, etc. Okay, but at the same time, Supreme Court also upheld the validity of the 24th Constitution Amendment Act. Supreme Court has validated the 24th Constitution Amendment Act. Okay. So, but this particular power of the parliament is subjected to the basic structure doctrine as Supreme Court given in the Keshananda Bharti case. But government was not happy. Why? Because Indira Gandhi government was very much radical in the implementation of the distributive justice. In that direction, she wanted to give a kind of a socialistic flavor to the constitution. For this reason, by means of the 42nd Amendment Act, okay, lot of changes have been brought, where preamble was amended to include socialist, secular and integrity. Apart from that, the authoritarian nature of the government was also reflected by the inclusion of the fundamental duties. Generally, fundamental duties will not be mentioned in any democratic constitutions, but these are mentioned only in the socialistic constitutions. So, by inclusion of the fundamental duties also, the socialistic flavor has been attained by the constitution. And moreover, in the Constituent Assembly also there was a debate whether the socialism has to be included into the preamble or not. Constitution makers were reluctant. Why? Because we are not following the original socialism that is followed elsewhere in the world. So, Indira Gandhi has gone against the intentions of the constitutional framers, still included the socialism into the preamble. Okay? And moreover, the socialism is also consolidated by the inclusion of the fundamental duties. Apart from that, there was also an effort to consolidate the powers of the parliament as far as the amendment of the constitution is concerned. For example, in the Keshananda Bharti case itself, as I told you, Supreme Court stated, yes, Constitution Amendment Act is not law, but at the same time, Parliament has a power to amend the constitution. But this amendment shall not be subjected to basic features of the constitution. So, in other words, effectively, the power of the parliament to amend the constitution is still subjected to judicial review. So, this was not digested by the government. Why? Because we do not want to give any scope to judiciary to question. For this reason, the 42nd Amendment Act of 1976 also facilitated another important thing, that is the inclusion of Article 368 Class 4 and Class 5. 368 Class 4 tries to grant the immunity to the Constitution Amendment from any kind of judicial review. So, no judicial review will be available. So, it means any amendment that is done according to Article 368 Class 2 of the Constitution, no court in the country shall be able to challenge such kind of constitution amendment. In other words, this particular Article 368 Class 4 is making the parliament to be supreme. So, in other words, you are trying to ensure the parliamentary supremacy. So, where the parliamentary supremacy can be seen in the UK's constitution. But what Nehru said, we do not want to imitate or we do not want to adapt the original provision in the UK system. Okay, rather we do not also want to embrace the originality in the American constitution. We want to make the synthesis. But here what you are able to see, the shift of the constitution from the semi-rigid constitution to highly flexible constitution, that is facilitated by Article 368 Class 4 of the constitution. Apart from that, even Article 368 Class 5 has made the parliament to step more in forward direction to make the parliament to be supreme. What is that? The power of parliament to amend constitution is unlimited. In other words, whatever the Supreme Court said in the Keshananda Bharti case in the form of basic structure, that has been completely nullified by 42nd Constitution Amendment Act. Okay. So the role of the judiciary is to protect the constitution. So that role has come into reality by another important case, that is nothing but Minerva Mills versus Union of India. Supreme Court has said two important things here. Number one, the Constitution Amendment shall not be taking away judicial review. Okay, because Supreme Court said the judicial review is also part of basic structure of the constitution. Okay, so when it is part of the basic structure, it cannot be taken away by means of the constitution amendment. And not only that, Supreme Court also said the constitution envisages balance between fundamental rights and DPSP. Okay, because 42nd Amendment Act also amended Article 31C of the Constitution. This 31C has been amended in such a way that not only the implementation of Article 39 Class B and Class C is protected, but also any fundamental rights implementation, if it violate Article 14, 19 Class 1 Subclass F as well as Article 31, no judicial review will be permitted. In other words, there was an effort on part of the Parliament to make the directive principles of state policy completely superior to fundamental rights. Okay, so when the DPSP has been strengthened at the cost of fundamental rights, means there will be a danger to democracy. Government's powers have been strengthened. On the other hand, the individual rights of the people have been weakened. So this is going against the very spirit of the Indian Constitution. So that is actually presented in the form of basic structure doctrine. Again, Supreme Court said the fundamental rights and DPSP are nothing but two wheels of same cart. Okay, how the cart cannot be able to move with one wheel, in the same fashion, Constitution cannot be functional without fundamental rights. So that's why fundamental rights cannot be violated at the cost of the directive principles of state policy. In this context, we are able to see two clauses of Article 368, Class 4 and Class 5 have been invalidated by judiciary in Minerva Mills case. Okay, this is very, very important. Okay, coming to what is there in Article 368, Class 1, Class 2 and Class 3. Okay, Class 1 regarding the power of Parliament to amend the Constitution. What is this power has been defined there. Class 2 explained about the procedure regarding the amendment of the Constitution. Class 3 explained that according to Article 13, Class 2 of the Constitution or Class 3 of the Constitution, Constitution Amendment Act is not law. Okay, so it tried to limit the judicial review power. Okay, and apart from that, Article 368 Class 4 granted immunity from judicial review. 368 Class 5 has provided unlimited power to Parliament. Okay, so now let us understand the implication of Article 368 Class 2 of the Constitution. Okay, Article 368 Class 2 provides about procedure to amend the Constitution. Okay, what is a procedure? Procedure is nothing but, first of all, a bill is introduced into either Lok Sabha or Rajya Sabha. Okay, it can be introduced, and this bill does not require prior assent of the President. Does not require prior assent of the President. In other words, the bill need not be a public member bill. It means the implication of this statement is simply bill need not be a public member bill, public bill. It can also be a private bill. So any member, whether it could be minister or an ordinary member, will be able to introduce this particular bill. Generally, the president will give assent only on the advice of the prime minister and council of ministers. So practically speaking, if any bill does not hold the support of the government, it can be difficult to be introduced into the legislature. But in the case of the constitution amendment bill, such provision is not there. Thus, such provision is only limited to certain kinds of bills, that is money bill, financial bill 1, financial bill 2. Okay, excluding these 3 bills, any bill does not require the prior recommendation of the president. Okay, and moreover, the bill is also being introduced in 2 houses, either Lok Sabha or Rajya Sabha. Okay, prior introduction can be taking place in Lok Sabha or in Rajya Sabha, right? Why this particular provision is mentioned, or why this particular facilitation has been provided? It is because India follows the federalism. Okay, and the constitution makers also try to balance both federalism as well as parliamentary form of democracy. Okay, in this regard, the Rajya Sabha must be given that opportunity for the prior introduction. Why? Because Rajya Sabha is the representative of states. When it is a representative of states, it must be given an opportunity for the prior introduction. So there is no requirement of prior introduction in Lok Sabha alone. It can be ensuring the prior introduction in the Rajya Sabha also. So that's why the Lok Sabha and Rajya Sabha are equal with respect to the introduction as well as passage of the bill. Moreover, when the constitution amendment bill is introduced, it must be passed with a special majority. So the special majority requirement is also mentioned under Article 368 Class 2. Okay, what is the special majority? The special majority is simply the bill must be able to get 2 requirements. It must satisfy 2 requirements. The requirements include, okay, A, the bill must be able to be passed by the House with 2/3 majority among members present and voting. This is the first requirement. And second requirement means this majority must be at least equal to half of the total strength of the House. So these 2 requirements must be met. Okay, that is, one is 2/3 majority among the members present and voting, and number 2, it must be able to attain at least 50% of the total strength of the House. And this bill shall be passed individually in Lok Sabha and Rajya Sabha. So bill must be passed individually in Lok Sabha and Rajya Sabha. So in other words, there is no scope for joint sitting. Actually, Article 368 Class 2 does not provide any joint sitting. Okay, joint sitting is available only for ordinary legislations. Okay, it is available only for ordinary legislations. Okay, actually the provision for joint sitting is provided under Part 5 of the Constitution. Okay, whereas Article 368 has been provided under Part 20 of the Constitution. So hence Article 368 has no connection with Article 108 of the Constitution. So hence there is no joint sitting. Okay, so in other words, in case any difference between Lok Sabha and Rajya Sabha regarding the passage, difference means nothing but deadlock, where the bill is passed in one house or rejected in another house, where the bill is not passed within the 6 months duration, or where the bill is passed in one house and passed on to the next house, and the second house does not accept the bill in a complete sense, it makes amendment, and this amended bill again forwarded to the first house, and the first house rejects the bill. So that is what called as deadlock. Okay, So in the case of the Constitutional Amendment Bill, if the bill is rejected by the second house, there is no scope for joint sitting. Okay, there is no scope for joint sitting. Moreover, Article 368 Clause 2 also mentions another important thing. What is that? The President does not have discretionary power to give veto. So in other words, there is no veto power, okay, that can be exercisable according to Article 85, Article 111 of the Constitution, according to Article 111 of the Constitution. So in the Article 111 of the Constitution, the provision for suspensive veto is provided. Okay, this suspensive veto is not available in the case of Constitutional Amendment. And moreover, this particular provision has been added again by 24th Constitutional Amendment Act. 24th Constitutional Amendment Act. Right? Why this presidential power to say veto has not been provided by the Constitution with respect to the Constitutional Amendment Bill? Okay, again we shall understand again in the dimensions of the parliamentary form of democracy. I told you the requirement of the parliamentary form of democracy and federalism have been integrated or synthesized. This represents the parliamentary form of democracy where the will of the representation or representative houses cannot be overridden by the president. Cannot be overridden by the president. So if the president says veto, again the bill has to go to Lok Sabha or Rajya Sabha. So in other words, not only it is overriding the authority of the parliament to amend the constitution, but it is also causing delays with respect to the constitutional amendment. So that's why in order to uphold the supremacy or the power of the parliament with respect to the amendment process, and in order to prevent the delays, the presidential veto power has been abolished by 24th Constitutional Amendment Act. Okay, right. So this is how we can understand this particular Article 368. And moreover, Article 368 also provides a special procedure for the amendment of the federal features of the Constitution. Okay, federal features means those features which are related to the relationship between the center and states, and also relative position of the central government and state government with respect to their powers. For example, if you want to change the status of high courts, if you want to change the status of Supreme Court, okay, if you want to make any changes to part 11 of the Constitution, that is center-state relations, or you want to make any changes to the 7th schedule of the Constitution, okay, if you want to make any changes to Article 241 of the Constitution, which is related to the high courts for the union territories. So in these matters, if you want to make any changes, even with respect to election of the president, okay, there is a requirement of special procedure. This special procedure has been put in place on the lines of the American system. In America, every amendment must be ratified by the state legislations, but in India, only federal features must be subjected to ratification by the states. So let us understand a small difference between ratification by states in USA versus India. Okay, in India, ratification is to be done by states only in federal matters. Okay, in USA, ratification is done in every matter. Okay, in USA, the ratification requires the support of 3/4 of state legislative assemblies. Okay, that is the states, the assemblies of the states or legislatures of the states. But in India, the ratification requires just 50% of state legislative assemblies, and it excludes the union territories. And in USA, the ratification can also be done by means of conventions. That is what called as states convention. All the states will be called, okay, with respect to their representatives, or these representatives will be making the ratification on behalf of the states. But in the case of India, there is no requirement of such states conventions. Okay. Moreover, in India, the states cannot initiate constitutional amendment. Okay. If any initiation of the constitutional amendment to take place, that must be done only by Parliament. But in the case of America, the states can initiate constitutional amendment. Okay. So this is how you are able to find the differences. Moreover, in USA, the constitution amendment can be initiated by American Congress or Constitution Convention. But in India, the constitution amendment shall be initiated only by Parliament. There is no Constitution Convention provided in the Indian Constitution. Okay, right. So end of the day, because of these particular reasons, we can say Indian Constitution is semi-rigid, because it can be seen as a synthesis between parliamentary form of democracy plus federalism, that is American system. Okay, right. This is how we can understand. Let us come to the question. Okay, consider the following statements. A bill amending Constitution requires prior recommendation of the President of India. As we have already seen, according to Article 368 Class 2, there is no such requirement. So hence it is false. Coming to the next statement, when a constitutional amendment bill is presented to the President of India, it is obligatory. Yes, it is obligatory. This is clearly given under Article 368 Class 2 of the Constitution. And a constitutional amendment bill must be passed by both Lok Sabha and Rajya Sabha by a special majority, and there is no provision for joint sitting. This is also true. So hence the answer is both 2 and 3. Okay. One more important thing, why joint session is not provided? Okay, in the Article 368 Class 2 of the Constitution, why joint sitting is not provided? Joint sitting is provided according to Article 108. Okay, in the case of deadlock between Lok Sabha and Rajya Sabha regarding the passage of the ordinary bill. In the case of the passage of ordinary bill, because of the joint sitting, the Lok Sabha may assume the predominance over Rajya Sabha. Why? Because when joint sitting is arranged, the Lok Sabha strength is more and Rajya Sabha strength is less. So if the government is having hold over Lok Sabha, and simply it can easily pass the concerned bill. So this results in the supremacy of the Lok Sabha over Rajya Sabha. So if this is permitted in the case of Constitution Amendment Bill, what will happen? The states will become subordinate to the center. States to subordinate to the center. But in the case of Indian Constitution, both states and center have to enjoy independent positions, and states are not considered to be subordinate to the center. Because of the joint sitting, what will happen? The states will become subordinate to the center. That is not envisaged by the constitution makers. That's why the joint sitting is not provided with respect to the constitution amendment. Moreover, the absence of the joint sitting also consolidates the concept called as supremacy of constitution. The supremacy of the constitution is nothing but which will be facilitating the federalism. Okay, right. So this is how we can understand various concepts. For more concepts, please watch KANISHKA IAS and please be subscribed.